Thank you all for joining us. End of the semester, super busy, crazy busy, but we have a great turnout. I appreciate all of you being here for this very important discussion. I have to say, I can't help but reflect upon the fact that what we're doing here at Notre Dame with respect to this issue compared to what's happening throughout the rest of the country and throughout campuses in the United States, while other campuses such as Columbia and Yale are responding to the war in Gaza by students screaming at each other and protesting and creating human blockades and shutting down classes and essentially extreme examples of intolerance. Notre Dame is promoting respectful dialogue. We engage at Notre Dame in respectful dialogue. In the past few months at Notre Dame Law School, just the law school alone, not other parts of the university, we've had a rich discussion about the issues related to Israel and the war in Gaza. In November, we had a wonderful discussion about anti-Semitism on college campuses. In January, we had a visit by Israeli Supreme Court Justice Alex Stein talking about Israeli rule of law. In February, we had a panel with Marilyn O'Connell discussing the details of the ICJ case brought by South Africa against Israel. In February, we also had a discussion about free speech and Palestine and whether or not there's a Palestinian exception with respect to free speech. And now today, we have a South African Supreme Court justice discussing the ICJ case from the South African perspective. So as I said, we already here in the past few months have been, I think, exemplars of respectful dialogue. Our strategic plan says it well. At Notre Dame, we recognize that a Catholic university confers an obligation to become knowledgeable, capable, charitable, to draw on all the intellectual, spiritual, and moral resources of the university to lead a rich human life inspired by the gospel that will help unify, enlighten, and heal. As with all these previous discussions that we've had related to this issue, today's discussion will be respectful. That's simply how we do it at Notre Dame, unlike other universities. The factual background leading to this case, I think, are familiar to all of you. On October 7th, 2023, Hamas and other armed groups, and I'm using the language from the ICJ here, other armed groups carried out a terrorist attack on Israel, killing more than 1,200 persons, injuring thousands and abducting some 240 hostages. As anyone that have watched any of the videos or read the reports, the brutality of those attacks shocked the world and permanently changed the equation of Israeli-Palestinian relations. Following the attack, Israel launched a large-scale military operation in Gaza shortly thereafter with the goal of eradicating Hamas from Gaza. With Hamas armed combatants embedded within the civilian population of Gaza, that operation is occurring in an urban environment throughout Gaza, causing significant civilian casualties, extensive destruction of civilian infrastructure, and the displacement of a majority of the population of Gaza. On December 29th, South Africa filed an application instituting procedures against Israel, alleging violations of provisions of the Genocide Convention. On January 26, 2024, the court issued an order on provisional measures in which it declined the measures requested by South Africa with regard to ending of hostilities, but granted South Africa's request for provisional measures, ordering Israel to take all measures within its power to prevent the commission of acts that violated the Genocide Convention. Those acts include killings, serious bodily harm, and other types of injuries with genocidal intent to destroy the Palestinian people. Israel's response to these provisional measures was that South Africa's application for provisional measures is unnecessary and unwarranted because, quote, they are unable to explain how significant measures undertaken by Israel throughout the present hostilities can possibly be reconciled with the genocidal intent to destroy the Palestinian people. And then they list the variety of different preventative measures that they've taken in the war in Gaza. And Israel further says that the current hostilities should be addressed within the framework of the law of humanitarian law, not the Genocide Convention, and the jus in bello should be the framework for the discussion of the war, not the Genocide Convention. Having granted provisional measures, the case is now under review to address the questions of jurisdiction and merits, which will be coming in the coming months. And of course, it's important to note that the South Africa case against Israel is part of a patchwork of other cases related to genocide that are currently before the ICJ. We've never had this many cases related to genocide before the International Court of Justice, related to Myanmar, related to the Russia's invasion of Ukraine and other matters. So we really are having a seminal moment with respect to the Genocide Convention before the ICJ. Today, we have the honor of hearing from Justice Leona Theron from the South African Constitutional Court. Notre Dame Law School, as you all know, has very close contacts with South Africa and the South African Constitutional Court. In fact, the history of the Human Rights LLM goes back to conversations that Richard Goldstone had with Ted Hesburgh about the need to help training lawyers to address apartheid, and the original genesis of our Human Rights LLM has ties to that conversation. Right now, on this very day, Dean Marcus Cole and Associate Dean Paul Miller are in South Africa to sign a memorandum of understanding with the University of Cape Town. We've had many occasions for opportunities to engage with the South African Constitutional Court. Justice Theron was here just this past April, a year ago, to talk about South African constitutional jurisprudence, and we welcome her back here today. Justice Theron grew up in Wentworth, South Africa. She received her bachelor's and LLB from the University of Natal and later completed an LLM in Georgetown on a Fulbright scholarship. She then returned to South Africa and practiced law for several years. In 1995, newly elected President Nelson Mandela appointed her to a judge to a white commission, which established to investigate the administration of the former regime and preparation for their incorporation into an integrated South African civil service. Between 1998 and 1999, Justice Theron served in various capacities as an acting judge in the Eastern Cape and the KwaZulu-Natal High Court. And in 1999, she was permanently appointed as a judge on the KwaZulu-Natal Division of the High Court of South Africa. At the age of 32, she was the youngest judge in the country and the first Black female judge in that division of the High Court. After serving on that court for 11 years, she was appointed to the Supreme Court of Appeals in South Africa, and in 2017, she was appointed to the South African Constitutional Court, where she serves today. Please welcome warmly Justice Theron.
Good afternoon. Thank you to Professor Alford for that very warm welcome and introduction and setting the stage, and welcome to Father Patrick also, who it's been my pleasure to meet and become acquainted to while I've been here. Thank you, all of you. I know you're in the throes of preparing for final exams, for coming, and for Monica especially and her team who have coordinated my visit. It's really an honor to be speaking here today to all of you. I've come to know the Notre Dame Law School as one of the finest institutions, producing great lawyers, producing lawyers who are going to make a difference even when they leave this institution. So yes, I'm placing that on you, that when you leave here, you're going to make a difference in the local community, in the international community. And hopefully today, when you leave, you will leave with knowledge as to how law can be used to make a difference, whether it's domestic law, regional law, international law. And I would like to say that there's a higher duty on us who know the law to use the law for the benefit of others. So I will talk about the case that South Africa brought before the International Court of Justice to give us a live contextual example of how the law can be used. And let me clarify right at the outset what the purpose of this lecture is, what my purpose is. It's to demonstrate how international law can be used as a tool to address even perceived human rights violations, to address perceived violations of international law. And I will discuss three themes today. First, the historical background to South Africa and why it was South Africa who brought the case before the ICJ. I will talk about the arguments made by both sides to the court, by both South Africa and by Israel when they appeared before the International Court. And thirdly, I will consider the reasoning of the ICJ. I must also add a disclaimer. As a sitting judge of South Africa, I am not in a position to express an opinion of this case. This is in accordance with our judicial code of conduct, and it may well be that some case or something linked to the conflict in Gaza might come to our courts. And if I express an opinion, then I would be forced to recuse myself from any matter that involves adjudication. And you wouldn't want me to do that. And I might even be found guilty of inappropriate conduct. Just to give you an example, no one is above the law in South Africa, not a judge of the highest court like me, not the Chief Justice. In 2021, our former Chief Justice participated in a webinar on the situation in Gaza. And during the course of the webinar, he expressed his personal view based on his religion about South Africa's relationship with Israel. His view was contrary to the view and the political view taken by the government towards Israel. And he was charged with misconduct. There was a complaint laid against him that he had willfully stepped into political controversy because he had made remarks about the Israel-Palestine conflict. And he was found guilty, and he had to, this is our Chief Justice, he was found guilty, and he had to issue an apology. And some of you might know that a former president of our country was sent to prison. So nobody in South Africa is above the law. Now, so I will plead for your understanding if at the end, during the Q&A session, there's any question that I'm not in a position to answer. So I'll start first with South Africa's past. And to place its case in context, most of you will know that South Africa has or had an apartheid past. South Africa was an apartheid state. For approximately 50 years, South Africa was under a racial segregation regime, a regime which the United Nations Apartheid Convention declared as a crime against humanity. Apartheid segregated South African people along racial and along ethnic lines. So based on your race, based on your ethnicity, that defined how you grew up in South Africa. That defined what kind of rights you were entitled to. When I was a little girl, I thought the world was made up of brown people, just like me, because those are the only people that I saw. In my community, there were only brown people. I went to a school where there were only brown people. My church was only brown people. And I believed that was the world. And it might surprise you to know, but it's a reality. There are white people in South Africa, or there were. After the dismantling of the apartheid, they would say, but I didn't know this is how it was in other neighborhoods, in other areas, because in their area, they thought this is the world. South Africa, the world is white. Everybody's living the way we're living, but that was not the case. So it was divide and rule by the South African government. And what was even worse is that racism, apartheid, segregation was institutionalized through law. It was enforced by law. Judges were called upon to enforce apartheid and racist laws. And the former Deputy Chief Justice of South Africa, Motseneke, he was called as an ad hoc member in the case of South Africa versus Israel. He said that justice in South Africa had a white, unwelcoming face. And all the people who were on the receiving end of these unjust laws were Black people. Now, to some extent, it was with the help of the international community, and again, I'm still dealing with the background. It was with the help of the international community that South Africa was able to transition from apartheid to democracy. There was international isolation, there was pressure, there were sanctions against South Africa from the entire world, trying to force South Africa to abandon the system of apartheid. Now, in June 1960, before most of you were born here, I think just Professor Alfred and I in the room may have been members of 10 independent African states. They met in Ethiopia and they adopted a 10-point program for sanctions in South Africa. 2 years later, the United Nations General Assembly adopted a resolution, and it said, we encourage all members of the United Nations to adopt the following measures against South Africa in an attempt to end apartheid. They were encouraged to break off diplomatic relations with South Africa. If they had no diplomatic relations, they were discouraged from starting diplomatic relations with South Africa. They were encouraged to close all their ports to vessels flying the South African flag. They were encouraged to enact legislation which prevented their ships from entering South African ports. They were encouraged to boycott all South African goods, to refrain from exporting goods, including arms and ammunition, to South Africa. They were encouraged to refuse landing and passage facilities to all South African aircrafts. Some states adopted those vehemently. Some states a bit more lukewarm, and some states ignored them. But that's the state of world politics. But I use that as an example to show how the international community can come together and stand together to support violations of human rights. As part of this background, during apartheid, the National Party government, and this was the party that introduced apartheid into South Africa, that government had strong relations and strong support with Israel. They had strong diplomatic relations with Israel, and they received strong support from Israel. So, to many Black people in South Africa, it was seen that Israel as a state was supporting the South African government that had enforced apartheid in South Africa. And then we had the liberation movement of the African National Congress. The African National Congress is currently the largest political party, the strongest political party in South Africa, and they control the government. So during the time of apartheid, while the government and the Nationalist Party had strong relations with Israel, the African National Party had strong relations with Palestine because they saw many similarities between South Africa and the situation in Gaza. And one thing that the South African government has maintained since 1994, since the ANC came into power, they have said, we will not forget our friends. We will not forget those countries who supported us, who supported the liberation struggle against the apartheid regime. So historically, Palestine has been considered as a friend of the liberation movement. And Israel was a friend of the Nationalist Party who started South Africa. Now, Professor Alfred has eloquently explained to us what happened on 7 October 2023. The world woke up to these brutal attacks that had been launched against the Israeli state and its civilians by Hamas, which saw over a day or 2 days 1,200 Israelis and as well as foreign nationals killed. Since then, and in the last 6 months, the State of Israel has declared war against Hamas and asserted as a justification its right to self-defense. It's also been reported in the last 6 months that 33,000 Palestinians have been killed during this war. It's been reported in the media the nature of this war that has been waged and that is being conducted by Israel. There's been attacks on schools, hospitals, refugee camps, power stations, mosques, residents. Maybe the residence was not the direct attack, but this was spin-offs from the main attacks, perhaps at places where Israel thought that Hamas was being held. In early January, the United Nations reported that humanitarian aid it was providing in Gaza was being cut off. This was detrimental to the survival of the people in Gaza. They didn't have adequate food, they didn't have adequate water, they didn't have adequate shelter, they didn't have proper hygiene and sanitation. And we know locally, nationally, domestically, internationally, the right to food, the right to shelter, the right to housing, the right to medical assistance are basic, fundamental human rights that every human being should have access to and should be entitled to. So these were largely the background events that led South Africa to launch its application at the ICJ. And it was South Africa's apartheid history that aligned, and the ANC, who is now in government in South Africa, that aligned them more to the plight and the suffering of the Palestinians and what was happening in Gaza. So let's look now at the legal arguments and allegations that were made by both sides before the court. So South Africa invoked the ICJ's jurisdiction under Article 36 of the Statute of the International Court of Justice. And this says that the court has got jurisdiction in all cases which the parties refer to it and all matters specifically provided for in the Charter of the United Nations, in international treaties and conventions. South Africa argued that the court had jurisdiction because because both South Africa and Israel were members of the United Nations and they were bound by the statute of the International Court of Justice. South Africa relied on Article 9 of the Genocide Convention. So it relied on the statute of the ICJ to found its jurisdiction. It relied on the Genocide Convention to found its case on the merits. Now, this is what Article 9 says. Article 9 says, disputes between contracting parties relating to the interpretation, application, and fulfillment of the convention shall be submitted to the International Court of Justice. So what South Africa said is, South Africa said there's a dispute between South Africa and Israel about how the convention should be interpreted and applied. And this is what gives the court jurisdiction. In its application papers, which were extensive, South Africa laid down the facts and of what had occurred in Gaza since Hamas had launched the 7 October attacks. It focused particularly on setting out facts, establishing that within the provisions of the Genocide Convention, and the jurisprudence of the ICJ, as well as the jurisprudence of other international cases, that a case was made out that the acts complained of against Israel violated fundamental obligations owed by Israel under the Genocide Convention. What evidence did South Africa use? South Africa used evidence in the forms of largely of statements, of interviews, and media addresses made by key Israeli state officials to prove the element of intent. So to establish genocide, you have to have intent. So the evidence that South Africa used, they used what the ministers were saying on national TV, the ministers of Israel, what the ministers were reported to have been saying in the press. And they said, if you look at the statements that have been made, those statements satisfy the requirement of intent to commit genocide. The papers are extensive. I'll refer to two examples that were cited in the application papers by South Africa. They said that on 28 October 2023, the director of the New York office of the High Commission of Human Rights resigned. And he resigned. He described the situation in Gaza as, and I quote, a textbook case of genocide. A month later, or about a week or two later, 8 special rapporteurs to the United Nations reported that they remained convinced, and I quote, that the Palestine people are at grave risk of genocide. So, based on these reports, video clips from the media, statements, South Africa argued that the conduct of Israel through its state organs as represented by high officials, they were acting on the instructions of the state or under the directions of the state. And they had violated Israel's obligations under the Genocide Convention. They relied in particular on Articles 1, 3, 4, 5, and 6, together read with Article 2. These articles said the following, that genocide is a crime under international law, Article 1. That genocide or conspiracy or an attempt to commit genocide is an offense under Article 2. That offenders should be punished regardless of whether they are rulers, public officials, or individuals, Article 4. That states must give in effect, or they must enact domestic legislation to give effect to the convention. Now let's go to Israel's argument. Israel didn't file a written response before the court. In a public statement made by the Israeli Prime Minister's spokesperson, Eylon Levy, and this was before the application. No, sorry, it was after. He said to reporters in Jerusalem that, I quote, "The state of Israel will appear before the ICJ at The Hague to dispel South Africa's absurd blood label." He further said that the Israeli foreign minister had sent a communication to all Israeli embassies across the world, and I quote, that Israel's strategic goal is for the court to reject the requests for an injunction, to refrain from determining that Israel is committing genocide in Gaza, and to recognize that the Israeli military is operating in Gaza according to international law. At the hearing itself, Israel strongly argued that there was no genocide being carried out in Gaza. It argued that Israel requested the court to remove the case from its general list. This means just to strike it off the roll. It argued that it had taken steps in order to address and alleviate the conditions of the people that was the conditions that the people were facing in Gaza. And it said, and this was its most important argument, that it was acting in accordance with international law in defending itself against Hamas. He said that the Genocide Convention was being invoked against it by South Africa in a war that it did not start, in a war that that is Israel, did not start, did not want, and all that it was doing was to defend itself from a terrorist organization. And he said the Genocide Convention was not designed to address the impact of hostilities on the civilian people. Israel also disputed the factual matrix that South Africa had placed before the court. And Israel accused South Africa of putting a narrative before the court which subverted the object and purpose of the Genocide Convention, and which, if upheld by the court, would have ramifications for all states who seek to defend themselves against those who demonstrate disdain for the law and for the rule. Israel also argued that South Africa's case, which they presented before the ICJ, ignored the events of October 7th. It ignored what was perpetrated and started by Hamas. They said that South Africa's case ignored events which resulted in 1,200 people being killed, in more than 5,500 people being maimed, and 240 hostages being taken. And he said, Israel said, if there are any acts that are capable of being characterized as being genocidal, it's the acts that have been committed against Israel. And it concluded its argument by saying it has an inherent right to take all legitimate measures to defend its citizens and to attempt to secure the release of the hostages. Israel said that the situation in Gaza was that of an armed conflict, and all it was doing through its military operations was defending itself. And Israel said it was acting within international law, within the Hague regulations, within the Geneva Conventions, and within customary international law. It also accused South Africa of not engaging in dialogue with it, of not giving it a reasonable opportunity to engage on matters which South Africa took directly, which it alleged South Africa took directly to the International Court. And it said that the measures that were being sought by South Africa were unnecessary, and it said the court should decline to intervene in that matter. The hearing of this case at the International Court of Justice was on the 11th and 12th of January at the Peace Palace at The Hague. The judges were all the usual members of the court. In addition, there were two ad hoc judges, one from South Africa and one from Israel. This case attracted attention from the world at large. Media houses across the world broadcasted the proceedings over the two-day period. And in what might even be a record for that court, produced its judgment 15 days later on the 26th of January. So the first question that the court had to decide was whether it had prima facie jurisdiction. Now, I must emphasize that whatever rulings were made by the court can be changed when it gives its final judgment. So it was just looking at whether, on the face of it, because that's what prima facie means, on the face of it, does it appear that we have jurisdiction? On the face of it, does it appear that there are rights that are being violated. And the court may change its may change its reasoning, may change its conclusion when it gives a final judgment. The court said it held that it may indicate provisional measures only if the provisions relied on by South Africa appeared on the face of it to grant a basis on which the court's jurisdiction could be founded. It held that for the court's jurisdiction to be founded, there had to be a dispute relating to the interpretation, application, or fulfillment of the Genocide Convention. In addition, the court had to determine whether the acts complained of had features or characteristics of genocide within the scope of the convention. The court found that at least some of the acts or omissions alleged by South Africa to have been committed by Gaza, and I emphasize they appear to be capable of falling within the provisions of the convention. Therefore, the court held that since both South Africa and Israel were parties to the Genocide Convention, and there was a dispute between contracting states relating to the interpretation, application, or fulfillment of the convention, that prima facie jurisdiction had been satisfied. And if you look at the judgment of the court, it says that the power to grant provisional measures has at its object the preservation of rights claimed by the parties, pending, and this is important, pending a decision on the merits of the matter. So the provisional measures only stay in place until the final decision is granted, which might be different from the provisional judgment. And I would like to read the following passage from the judgment of the court. The court said, in view of the fundamental values sought to be protected by the Genocide Convention, the court considers that the plausible rights in question in these proceedings, namely the right of the Palestinian group in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Convention, and the right of South Africa to seek Israel's compliance with its obligations under the Convention are of such a nature that prejudice them and is capable of causing irreparable harm. So that was the basis of the reasoning of the court, that the allegations seem to show that there are people in Gaza who are suffering irreparable harm. And I list 4 of the measures that the court said, mainly for Israel to comply with. It said Israel must take all measures within its power to prevent and to punish the direct and public incitement to commit genocide. Israel must take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip. It also said Israel must take effective measures to prevent the destruction and ensure the preservation of evidence relating to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention against members of the Palestinian group. It said that Israel must report to the court on all measures that it had taken to give effect to that order within a month of the date of the order. It also said that this report will then be provided to South Africa to enable South Africa to comment on it. The court's judgment was not unanimous. Judge Sebutinde wrote a dissenting judgment. The judge said that the dispute between the State of Israel and the people of Palestine is essentially and historically a political one. And it's a problem calling for a diplomatic and negotiated settlement, not a settlement in the court. I'm going to try to wrap up very briefly. Now, many commentators have said, why didn't the International Court of Justice do more? Why didn't it order a ceasefire? The South African Minister of International Relations specifically expressed the unhappiness of South Africa that the word cessation or ceasefire was not included in the judgment. Israel was also unhappy with the judgment. President Benjamin Netanyahu is alleged in the media reports to have labeled the judgment as outrageous. Now, there are other commentators who have said the court could not have done more than what it did because of the restrictions on its power. And one of the biggest challenges was that Hamas is not a state over which the ICJ has jurisdiction. Hamas is a party in the conflict, but it was not a party before the court. So the ICJ could not have ordered Israel on the one hand to have a ceasefire, and Hamas on the other hand would have had no directions or no orders over it. There was a subsequent development where South Africa went back to the court to say that the provisional measures were not being followed. The court agreed with the subsequent application, and this is what it said. It said, this perilous situation demands immediate and effective implementation of the provisional measures indicated by this court on 26 January 2024. The court emphasizes that the State of Israel remains bound to fully comply with its obligations under the Genocide Convention and with the said order, including by ensuring the safety and security of Palestinians in the Gaza Strip. And the court held that, this is in the second application, that the living conditions of many people in Gaza had further deteriorated. And they were no longer facing a risk of famine, but that famine was settling in. Now, I make one or two concluding remarks. I hope that we can see from this case, regardless of which side we may morally or legally support, that international law serves several important purposes. It can assist to maintaining order, to resolving conflicts, and either, as it also assisted, in the transition from apartheid to democracy. The interventions can be aimed at protecting individual human rights and individual freedoms. And as I said at the beginning, I will add that domestic and regional law can also be used in this way within a country. And even at a local, at a domestic, at a regional level, if a state or a country is part to an international convention, international law can be used in a local case as well. We have seen lots of this in South Africa, where we have an active civil society wing, and our courts, particularly the Constitutional Court, has interpreted the question of standing broadly. So somebody not actually directly involved in a dispute can present, or even an organization can present a court, can present a case on behalf of others, trying to improve the situation of ordinary people. There's a duty on all of us to make a difference, to use the law when we see an injustice. And we can perceive an injustice as well. We might not be right, but don't sit by. If you perceive that there's an injustice, take action so that there can be justice for all. There's a duty on all of us to strive for justice for everyone. This accords with the words of Martin Luther King Jr. that injustice anywhere is a threat to justice everywhere. And on this note, I conclude. And I'd like to thank you all for attending today, for the respect that you've accorded me, that you've accorded this university, for the tolerance, and for that kind of behavior to continue. Many of you represent future world leaders, and it is to you that we will look to be agents of change in the future. This is a sensitive and divisive subject, but we should be able to have dialogue on any subject, and that's why we're here today. And it is only through dialogue that we can share, engage, and understand different positions. And it's through dialogue that we can eventually turn war into peace. So I thank Notre Dame Law School for giving me this platform, for giving me the opportunity. Thank you to Professor Alford for moderating and setting the tone under which this conversation will be held. And thank you all for coming today, and we thank the Dean in his absence. Thank you very much.
That was wonderful. So I'll moderate the questions, and then you can respond. Let me just start with a question that I think you alluded to at the very end, which is this situation of asymmetrical warfare is also leading to a situation of asymmetrical litigation, where there is no avenue or venue for Israel to have a judicial recourse to address either the events that happened on October 7th or any activities that have happened in the current conflict or in the future. And so they simply do have no recourse to have a judicial pronouncement about the behavior of Hamas. And then related to that is South Africa has standing in this case only because of the nature of the Genocide Convention, the erga omnes partes idea of standing. You're not an interested party in the traditional sense, but because of the nature of the Genocide Convention, they say all states have standing to address the concerns about the Genocide Convention. But what that means in practice is that the ICJ will not issue any orders against South Africa because you're not involved in the conflict. Unlike Russia and Ukraine, where they can issue orders on both sides of the conflict in adjudicating that genocide question. In this situation, it's asymmetrical in the sense not only of Hamas is not a party to the case, but South Africa will never be ordered to do anything because they simply are there as a representative of, I guess you could say, the community of nations, right? Do you want to just respond to that? That sort of asymmetrical litigation problem?
And just thinking on my feet, what South Africa could also be directed to do, and that was part of the complaint of Israel, is to engage with Israel, to have bilateral conversations with Israel. So Israel was saying, South Africa is not talking to us. South Africa is not coming to us to sit around the table and understand our position. So it might in the future be something that the court could direct, or if South Africa then has such a good relationship with Hamas, for South Africa to bring Hamas to the table as well to talk to Israel.
Mm-hmm. Right. Open up for questions. Yep. Krista?
I have two questions. So in the beginning, when we were talking about the procedural posture, it sounded like South Africa offered multiple theories, not just the Genocide Convention as a potential basis for standing. So I wanted to ask if the court, it sounded like the court only relied on the standing idea related to the Genocide Convention explicitly, but if it had gone with a different medium of the UN Charter or something else, would that have changed the remedies that maybe the court would have been able to provide, or how will that shape the litigation continuing in the future? And then the second part of my question related to what Professor Alford just said about parties or things that South Africa were required to do. Since the court did accept the Genocide Convention as the procedural posture of the jurisdiction, does that in any way affect, does South Africa's nexus of relationship, particularly with this conflict and with the opposing parties here of the Palestinian
In respect of the first question, I'd say watch the space. And let's look out for how that is dealt with, if it's dealt with in the final judgment. Because the court here was under time limits and time constraints to produce a judgment within 2 weeks. And what I know from my own experience, when you have that limitation, you try to find common ground against the majority of within the majority of the judges. So it may well have been that in that limited time, they could see there were dissents or dissenting views on other grounds or other treaties, but most of the judges there felt the same way, what we say ad idem. There was consensus about the Genocide Convention. I'm speculating, and I'm using my own experience to say what could have happened. And we may in the future even see more dissenting judgments. Talking about the relationship between South Africa and Israel, your second question, there definitely in the past few months has been a deterioration of the relations between South Africa and Israel. There have been many protests within South Africa as well, pro-Palestine, against Palestine. We are certainly a divided nation. And I think I'm aware, or the South African government would have been aware of the possible ramifications of the deterioration of its relationship with Israel when it took this matter to court. I think Israel, the national airline, the national carrier, doesn't fly to South Africa anymore. And certain embassies have also been closed within South Africa and South African embassies in Israel.
Other questions? Yep.
How does
Mackenzie?
the South African population view South Africa's involvement in this case?
Diverse. There are those who support the African National Congress and support the government. There are those who support the State of Israel. We have a large Jewish community in South Africa. And was it before, with the attacks on Jewish people in Europe, many people found refuge within South Africa. Many Jewish people found refuge within South Africa. We have large numbers of South African-born Jewish boys who go and fight in the army and do national service in Israel.
Yep.
Thank you so much for coming to speak with us today. Dr. Alan Bosa from South Africa spoke earlier this year and talked about how, in the eyes of South Africa, the ICJ case was kind of doing what they could on the international sphere. They don't necessarily have the same power that a country like the US has, who can veto Palestinian statehood or veto UN Security Council resolutions. Can you talk a little bit, just from your experience on the global sphere, what that looks like for countries to use international laws, again, like the Nicaragua versus Germany case right now, also involved with Israel and Palestine, just what those dynamics look like on the global stage for countries which might not have the power to lay down the law.
I think, as Professor Alford mentioned when he came after my address, or in the beginning, that we are at a seminal point in history. And I think whatever you say, whatever you feel about South Africa's case to the ICJ, what it has demonstrated on the international plane, how international law can be used to intervene in conflicts. And it's also shown that it need not be by a party as well directly involved in the conflict. I think it says to the world, stand up and take a stand.
Thank you very much. My name is Malik. I'm a graduate from South Africa, born and raised in Johannesburg, studying computer engineering. Yes, so I chose numbers over words. A friend of mine who is a Palestinian, who's also in college of engineering, had to take a semester off because she couldn't find family in Palestine. So I just wanted to ask, practically speaking, how does international law help people?
I would start off by saying that's a very sad situation, and to emphasize that there are so many casualties of war, thousands and thousands of casualties of war. The question is, how do we deal with the casualties of war? And it would have to be, I think, making use of international organizations, UN aid organizations that provide that kind of assistance, who go in different organizations and making and Red Cross or whatever, but that's the assistance that needs to be provided. But I think that is a first-hand example of the casualties of war, of the people that you know. Those numbers that are reported of 1,200 people dying, of 33,000 people, including women and children dying, that's but just one face of it. And you can see how that affects a family. So war has serious ramifications for citizens that get involved in that conflict. And there's at least 3 South Africans in the room today. Well, no, I'm sorry. 1, 2, 3, 4, 5 South Africans. Yes, he's just stepped out. So yeah, welcome to all the South Africans, especially.
Yep. Maria?
Question that's mostly theoretical. So, generally speaking, in international law, the actors, the right holders, and the duty holders are states. So, how do you deal with certain private actors or private groups like Hamas in this case? How can the board do an effective work regarding these kind of different actors that are being part of the case?
The difficulty in this matter, and that this case showed, is that the court had no jurisdiction, the international court had no jurisdiction over Hamas. That might be different in a domestic court. In a domestic court where Hamas or members of Hamas that has jurisdiction, where they're being tried, maybe civilly, criminally, for acts of genocide. But the difficulty was who would bring that case domestically or in a territory where that court has got jurisdiction over Hamas. And I think that is what the dissenting judgment speaks to, a political and negotiated settlement where the courts fail.
I'm able to ask a follow-up question, very short. Did you say that the Palestine nation, I don't know what's the name of the state, is the host of these terrorists, so they have certain liability to sort of like try to stop their actions?
I think it's a difficult question. Hamas operates largely from Palestine. They are citizens in Palestine. I don't know how far you can say that Palestine as a country and the state hosts them or supports, or to what extent, if any, supports their activities. They call themselves a liberation movement.
Can I respond just
Yes.
additionally?
Yeah.
So Palestine is, as a formal matter, they're not a member of the Genocide Convention, and so they can't be subject to any orders from the ICJ, and they cannot themselves bring an action against Israel because they're not a signatory. Your question is a good one, though, and I think the ICJ alluded to this a little bit. You know, obviously they talked about the facts of the case and what happened on October 7th, but in the very, very end of the order, they do make a reference. I think it's probably dicta, but I think it's an interesting statement by the court. The court deems it necessary to emphasize that all parties to the conflict of the Gaza Strip are bound by international humanitarian law. It is gravely concerned about the fate of the hostages abducted during the attack in Israel on October 7th and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release. So that doesn't have any force behind it because Hamas is not a party to the case, but I think it's an important attempt, I guess, in some way to make a statement about that.
Yes.
Right.
Yeah, no, I agree 100% with that. And I think if we have more statements and directions like that on both sides, we possibly can see an end.
Okay, I think that may be it. Let's welcome and thank Justice Theron very much. This is a tradition. Every April, she's going to come back, right?
I'm happy to. Thank you.